there, this is Pat Ennis of Ennis Legacy Partners. Welcome to the Exit Readiness Podcast. I'm here with my co-host, Walter Dial, tax partner and CPA at Gelman, Rosenberg & Friedman. CPA is located in Bethesda, Maryland. Our mission here on this podcast, the Exit Readiness Podcast, is to provide you, the business owner, with subject matter expertise on topics pertaining to building transferable business value or sellable business value, and for planning your eventual exit from the business. We want to help you, the business owner, exit successfully and on your own terms and conditions. A sale to a strategic or a financial buyer can often be the best exit route for a business owner to accomplish whatever their goals they have, financial goals, value-based goals, legacy goals. If you're an owner who is selling and have never sold a business before, you may have questions about what professional advisors you would need on your team. One advisor that can be critical to a successful sale transaction is an M&A attorney or a mergers and acquisition attorney. Today, we're going to provide you with information regarding the role of an M&A attorney in a sale transaction.
Our guest today is Scott Taylor, business attorney at Smolen, Plevy in Tysons Corner, Virginia. Scott's practice areas include corporate and business law, including entity formation, ownership structure planning, corporate governance and mergers and acquisitions, real estate, and tax-exempt organizations. He's a member of the Virginia State Bar and is admitted to the United States Tax Court and the United States Court of Appeals for the Fourth Circuit. Scott earned his Juris Doctor Cum Laude from the George Mason University School of Law in 2001 and a Bachelor of Science degree in business from Virginia Tech in 1992. Scott has many years of experience serving business owners in successful sales transactions. Pat and I both worked with Scott, and we're very happy to have him here with us today. Scott, great to have you join us. Thanks so much for taking the time.
Absolutely. Thank you for having me.
So let me just ask you kind of a general question to get started. A business sale transaction takes place in stages. So from a legal standpoint, what do you consider to be the phases that a sale transaction goes through?
It can take different forms, but generally speaking, there are, I tend to break it down into five separate phases. And phase one would be preliminary discussions, and that can be anything from a buyer and a seller sort of meeting at a conference saying, hey, maybe it makes sense for us to talk about joining forces or something like that. But that's sort of a preliminary discussion level. Phase two is when things have gotten a little bit more serious and the parties are actually moving towards a transaction. And phase two would be due diligence, which is where the buyer and seller are exchanging information, and it's primarily the seller exchanging information to the buyer to get them up to speed on the business that is the target of the sales transaction. And phase three would be the stage where you're actually getting down to the definitive documents, negotiating the actual documents that are going to paper the deal. And due diligence is still going on at that time when those documents are going out. But the due diligence sort of informs the drafting of the definitive documents. And then, of course, once the definitive documents are set and negotiated and everybody's comfortable and the deal is set to go, of course, you have phase four would be the closing. And then you have phase five, which is post-closing. And post-closing, depending on the structure of the deal, you often have things like earnouts. And oftentimes the sellers are still involved in the business as employees going forward. So there's issues there. And then, of course, there are things with that can come up that do implicate the definitive documents, such as indemnification claims and that sort of thing. So that would be the post-closing phase.
Yeah, that's really helpful. And I think Pat has experienced this as well. A lot of clients for selling their businesses, they think, when they get that offer, it's like, oh, great, my business is sold. But like you just laid out, it's a long process to get from start to finish. And it's got lots of traps for the unprepared and unwary.
Oh, absolutely.
Yeah, so if a business owner, Scott, is thinking of selling their business, when should they engage an attorney that does the work that you do, an M&A attorney?
The short answer is as soon as possible. Realistically, because of schedules and various things and the way some of these transactions roll out and discussions progress, sometimes it doesn't happen till till a little bit further down the road than attorneys would typically prefer. But generally speaking, as soon as possible, and certainly you would want to have an attorney involved before you started exchanging, let's say, confidential information, and that can even financial information, certainly confidential business information. Because what you want to have in place for that is a confidentiality agreement, obviously, so you can sort of be comfortable that there's some level of protection involved when you are actually disclosing information to the potential buyer. So you certainly want to have that in place, and you certainly want to have an attorney in place to at least have that confidentiality agreement in place. And that's usually something that the seller would want their own attorney to draft, because it's generally speaking the seller's confidential information that needs to be protected in that arena. And that also gives the attorney the heads up that the transaction is coming. And that's oftentimes the first time that the attorneys are brought in. I guess that there's a long-winded way of saying basically as soon as possible, because things start to have legal implications a lot sooner than sometimes sellers realize.
Yeah, so Scott, even like during phase one that you described as the preliminary discussions, I mean, legal documents start flowing back and forth. Can you kind of describe some of those documents?
When you're even in preliminary discussions, you have the confidentiality agreement, like I just mentioned, and the documents that flow back and forth, and really that sort of usually in the preliminary discussions, often the first documents that go back and forth, hopefully a confidentiality agreement is in place, or financial documents and that sort of thing. But typically the next document that you tend to see is some form of formal offer, which is usually in the form of a letter of intent. And so in the letter of intent is really where you're starting to really provide an outline for the deal. And that's something, it's basically where the parties are, the discussions have sort of progressed to the point where it's sort of, okay, we sort of have an idea of how we want to structure the deal. And here are some of the key points that we want to focus our negotiations around, and how this deal is going to be structured. And it usually an LOI will cover things like, whether this is an asset or a stock sale, pretty basic. And we can talk more about the differences in those. What's the purchase price, and how is that purchase price calculated? Is it just straight up, this is, cash at closing? Is it based on a formula? Is it paid some up front with some based on an earnout? All very important considerations, particularly for the seller. Are there net working capital requirements? Basically, that means essentially is the buyer asking the seller to keep a certain amount of working capital in the company at closing, that sort of thing. How is the purchase price paid? Again, going back to the purchase price, is it all cash at closing? Is it cash with some sort of holdback for a period of time, plus an earnout? And if there is an earnout, what are the parameters for that earnout? Some of it's not at a level of detail that you would see obviously in the purchase documents, but it's basically throwing the idea out there that this is how we're going to have the purchase price paid. And what are some of the other conditions to closing? Do leases need to, if it's an asset sale, do leases need to be assigned? Are there any third-party consents that are needed? That sort of thing. It can even include things such as an allocation of purchase price. If it's an asset sale, you're going to want to figure out how the purchase price is allocated among the assets. So those are some of the key points that you find in an LOI, and that's usually after the confidentiality agreement and documents have gone back and forth a bit. The buyer's in a position to present its offer, and that's usually in the form of an LOI that contains those elements usually.
Yeah, so there's a lot of legalese going back and forth right off the bat. So it just makes it really critical to get your attorney in there quickly. And I think also, like Pat and I are always telling people, maybe the attorney you're used to working with is not familiar with sales transactions. So you really need to get an attorney who is familiar with this stuff, because it is very specialized.
Well, so they generally take in broad terms the generally three types, and so there's a stock sale, which is, again, it's the owners selling the stock of their company to the buyers so that the buyers then own the target company. There's an asset sale, which is basically the target company is selling the assets and the going concern of the business to the buyer. And then there's mergers, and more times, most of the time, mergers that we tend to see involve larger companies with lots of shareholders and more complex transactions. The type of transactions that I typically see are either asset sales or stock sales, and there's different reasons for both, it depends on the nature of the deal to determine what makes the most sense as far as a stock sale or an asset sale.
Yeah, so hey, Scott, describe what would actually be protected from liabilities in an asset sale versus a stock sale.
Sure. So and that's one of the key differences between a stock sale and an asset sale, and the other is for tax reasons, buyers tend to prefer asset sales. But so generally speaking, buyers tend to prefer asset sales, one for the limitation of liability, Pat, as you just described, and also for tax reasons, because the buyer gets to then allocate the purchase price among the assets for depreciation. In a stock sale, sellers tend to prefer stock sales because they get capital gains, generally speaking, on the sale of their stock. So they prefer that. But the buyers tend to shy away from a stock sale if they can. One reason being for the limitation of liability. So when you're simply buying the stock, you're taking ownership of the target company with all of its skeletons in the closet, so to speak. So there is no limitation of liability because you're assuming ownership of the company itself. So all of the assets and liabilities within the company stay within the company. In an asset sale, what you're doing is the buyer is coming in and taking out all of the assets of the company and the going concern value of the company, and taking it out of the existing company and putting it into a new company that they formed for the purpose. And there are some situations that change the scenario, but generally speaking, absent an express assumption of liability, the buyer is not assuming the liabilities of the seller. Those stay with the selling entity. And again, that's generally speaking, but that's why buyers tend to prefer asset sales as from the liability perspective, because they can sort of pick and choose which liabilities they want to assume. Now, some of the assets may be encumbered, and the only way to get them is either pay off the debt or you're taking the liabilities with you out of the company. But generally speaking, you can leave the liabilities of the business in the selling entity when you do an asset sale.
What are the typical, let's say, definitive documents that you M&A guys would term as papering a deal?
Right, sure. So in an asset purchase, you'd have an asset purchase agreement. In a stock purchase, you'd have a stock purchase agreement. They generally have the similar form. The difference being in the one you're buying, the stock purchase, you're buying the stock, and in the asset purchase, you're buying the assets of the target company. There's usually some form of employment agreements, oftentimes for the selling owners, if they're seller operators, and especially the likelihood is that the buyer is going to want to have those seller operators stay on as employees for some period of time. And there may be employment agreements for other key employees and that sort of thing. There'll be non-competition, non-solicitation agreements in place, and then general sort of sale documents like bills of sale, assignments, that sort of thing. Often there's an escrow agreement if funds are going to be held in escrow, usually the purchase price. If there's certain conditions to the release of a certain portion of the purchase price, oftentimes that's held in escrow pursuant to a separate agreement. And once the conditions are satisfied, the money is released. And then there's other documents that can be specific to the transaction. For instance, if there's franchise transfer documents or those types of things that involve third parties that need to either be assigned or new documents put in place.
So Scott, you've had a successful closing. Is your role pretty much done at that point, or what happens?
Well, and I sort of alluded to this earlier. The answer is no, because there's usually some issues that come up post closing, such as like I said, there's usually the employment agreement. So sometimes the sellers as employees, issues may arise under their employment agreements. There may be issues such as with the earnout, particularly if it's a complex formula and there's questions about whether the earnout's been calculated correctly. There'll be issues that can relate to that, where you have to look at the documents and see if things are being calculated correctly. And there's also indemnification claims, things that come up post-closing that relate to liabilities of the business pre-closing. The buyer is basically making a claim against the seller, saying, hey, this either violated one of the reps and warranties, and therefore we're making a claim under the indemnification or something along those lines. So no, the role of the attorney still is there, and it's usually the attorney who drafted or was at least involved in the documents to begin with is usually the place to start, because they're familiar with the way the transaction was negotiated and are familiar with the documents and are usually brought in to address those sorts of post-closing issues.
Yeah, I've experienced that before, where there's been a dispute, like a year and a half later, and they're trying to use different attorneys, and it just makes it much more difficult, because the attorney who did the original paperwork kind of has a much better idea of what the intent was.
Oh, sure. Yeah, absolutely. And is usually can much more quickly get to the real heart of the matter, depending on what the claim is. Yeah.
Right.
That's exactly right.
Yeah. So Scott, to wrap us up here, two more questions, if you will. Any general advice you would give to listeners who are just starting to think about exiting? And then also, we're often asked this question: what's an M&A attorney do that an investment banker doesn't do, or how do they work together? So any general advice you would have here at the end, and then also the working relationship that an M&A attorney would have with an investment banker.
Sure. So general advice would be, if you're thinking about selling, again, the thought process should start early on, and should almost really be an ongoing sort of issue for a business owner, because it's better to have things in place all along, let's say, than to put things in place when you have a potential buyer that's interested. So by that I mean things like just having things like key employees under employment agreements and non-competition agreements, and maybe some incentive agreements to stick around through a sales transaction kind of thing. Those types of things, if you can think about it early enough to get them in place, you have the business sort of teed up with legal documents, not just from a business perspective and doing the business, but with legal documents that buyers will look at to say, okay, this looks like everything's in good shape to just sort of transition over to a new owner. The biggest concern, of course, is making sure the business is run well and focused on the actual business of the business, but you want to make sure the legal issues are covered as well. So it's a good idea to have an attorney involved, like I said, early as possible, but even earlier than even if you're actively thinking about selling a business. But you certainly want to have an attorney involved as early on in the actual sale process as possible, because, like I said earlier, legal issues can arise and legal implications can arise a lot earlier in discussions than a lot of sellers, I think, realize.
Yeah, and then the question about investment bankers.
Oh, sure, right. So the role of the attorney, one is investment bankers and attorneys have similar roles at times, but of course different roles. Obviously, investment bankers can't give legal advice. So the role of the attorney is to give the legal counsel to the seller, especially to highlight potential legal areas of concern that a buyer may be looking at, or to find those areas of concern that a buyer may highlight and address them before they become an issue with the buyers, as well as negotiating the documents. A lot of it comes down to experience, which is where investment bankers with their knowledge base can inform the business decision of, is the business deal structured properly? Do the business terms make sense? And the role of the attorney, based on experience, can also inform that. But really, it's the role of the attorney is to provide the legal advice, close the legal loopholes, close the legal areas of concern, and watch out for potential pitfalls that may become larger legal issues if they're not addressed down the road.
Yeah, very good. Yeah, so it would not be unusual for the work that Walter and I do in comprehensive business planning or exit planning to, we've gone through the process. We've helped the owner to clarify all their goals, value-based, financial, legacy goals, that type of thing. We've assessed both their business readiness and their personal readiness, done some pre-tax planning. Walter would get involved in doing that, of course, and then an estimate about value for the business, something else Walter does. And all these things, all these different pieces, and it would not be unusual in a situation that we would have where the right route for that particular business owner is indeed going to be to sell to either strategic buyer or financial buyer, to have both an M&A attorney like yourself on the team, as well as an investment banker on the team. The investment banker really doing a lot of the marketing piece and bringing the business knowledge and industry knowledge to the transaction, where Scott, you might be the M&A attorney providing the legal counsel. So an exit planning team of advisors and a third-party transaction, and from an exit planning, comprehensive exit planning perspective, absolutely can have both the M&A attorney and the investment banker on the team.
Absolutely, and they both serve very valuable roles. So, but they don't replace each other. They may have some overlap, but they don't replace each other. So there's absolutely a necessity for both to be on the team.
Well, Scott, this has been really very, very helpful. So we really appreciate you coming on the podcast. So if anyone listening today would like to contact you, how should they do that?
Yeah, great. And I'd just like to say thanks for having me. I've really enjoyed the discussion. And yeah, to contact me, my the name of my firm again is Smolen Plevy. My phone number is 703-790-1900. And my email address is swtaylor@smolenplevy.com. I'll spell that SMOLENPLEVY.com.
Great. Thanks, Scott. Really enjoyed it. And if any of our listeners would like to reach out either to Pat or to me regarding either building the value of your business or planning your exit, you can reach Pat at 301-859-0860, or you can reach me at 301-951-9090. Until next time on the Exit Readiness Podcast, this is Walter Dial and Pat Ennis signing off.